If a lawsuit hit tomorrow, could a judge grab your real estate? In the next several minutes, I'll show you how to lock down real estate so effectively that most plaintiffs' lawyers back off without selling a single property. The core: one land trust per property for privacy, an LLC as beneficiary, equity stripped out with liens, and proceeds parked in an LLC inside of a Cook Islands trust. So control when it's calm, protection when it's stormy. So stay with me and I'll reveal the single filing that quietly kills most contingency cases. I'm the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. I've been in the asset protection business for 34 years, and I've set up Cook Islands trusts for nearly 30 of those. Our firm has established more Cook Islands trusts than any group in the world because when a serious lawsuit hits, this structure works. And if this helps, hit subscribe now if you haven't so you don't miss the advanced tactics. And if you want it built for you, head on over to assetprotectionplanners.com. Okay, the biggest mistake. The classic mistake: deeding U.S. property directly to a foreign trust. A domestic judge can still control local dirt. So picture it. Nice offshore trust, but your apartment complex is on my turf, says the judge. I'm appointing a receiver and selling it. Real estate is immovable. Courts don't need your cooperation to act on a building on Main Street. So we reverse the game. Except that the dirt must stay. Make sure the equity and control levers do not. So we separate title, owner, and collectible value so a would-be attacker can't draw a straight line from you to cash. Okay, let's talk about the 4-layer shield. Layer number 1, privacy, and that is a land trust here. Each address sits in its own land trust. Public records show a trustee and a trust name, not you. Privacy isn't invincibility, it's friction, and predators prefer easy targets. The trustee, usually a Wyoming LLC with a Wyoming address that we set up for you that has nominee privacy so your name doesn't appear in the public records. So there's the land trust. That's layer number 1. Layer number 2 is an LLC. The beneficiary of each land trust, other than your primary residence, is an LLC. This places economic interest behind an entity that often offers charging order protection, turning a judgment into a wait-and-see coupon instead of a grab-and-go. Okay? Next, layer number 3, equity stripping liens. What we do here is we drain visible equity from the property with commercially real mortgages and lines of credit. If a lawyer sees $2.5 million liens on a $3 million asset, his calculator starts arguing with his ego. Okay, layer number 4 is the offshore vault. Cook Islands Trust plus LLC. The money and claims go into your Cook Islands LLC that's owned by your Cook Islands Trust. In calm seas, you manage this LLC here that's inside the trust. So this is where the proceeds from your mortgages go. This is where the liquid assets goes. And then when litigation hits, our licensed bonded Cook Islands Trustee Company law firm steps in to protect you only when needed. Think about it. The courts take people's money all the time. Our Cook Islands trustee, where we've been setting up trusts for 30 years, have a track record of perfect integrity. So cliffhanger here. In a few minutes, I'll show you how one U.S. filing often turns a 7-figure fight into a modest settlement discussion. Okay, next, land trust here. Land trust. One property, one land trust. A land trust is a simple title holding arrangement. Trustee on record, beneficiary off record. This superpower is privacy, because the trust itself doesn't get recorded in the public records, so nobody knows who the beneficiary of that trust is. They just know the property is titled to a trust. So the deed showing that the trust owns the property, the trust/trustee owns the property, is in the public records, but who is the beneficiary of that trust is private, secret. You get to keep that land trust in your filing cabinet at home. So when your name isn't on title, many contingency fee firms can't instantly inventory you, and some stop right there. So why one trust per property? And the answer is containment. Slip and fall at the fourplex shouldn't bleed liability into the lake house or your duplex. Each trust is a compartment with its own watertight door. Here's how the mechanics work. We deed from the current owner, let's say Pat Smith, to 123 Oak Street Land Trust with a neutral trustee, which we usually set up in Wyoming, a Wyoming LLC that you own privately. Private trust agreement naming the beneficiary. So we design the trust so that you can swap beneficiaries or trustees quickly if needed. Okay, how about the due on sale clause for the mortgage property? For an owner-occupied primary home or 1 to 4 dwelling units, whether you live in it or not, the federal Garn-St. Germain Depository Institutions Act of 1982 provides an exception for inter vivos trusts like the land trust we set up. For rentals and commercial, lenders usually care about payments, taxes, insurance. So we stage moves, communicate when appropriate, and follow the lender covenants. Okay, next step is the LLC down here. Okay, for the LLCs, if you are the beneficiary of one of these trusts, a personal judgment can reach that beneficial interest. So when an LLC is the beneficiary, a creditor often faces a charging order, the right to distributions if declared, not the right to seize assets or vote your membership. So that turns we're taking your building into maybe someday if there are distributions. So why not use the LLC over here on your personal residence? And there are 3 reasons. Number 1, homestead protections may weaken. Okay. Number 2, insurance classification and property taxes can shift. And number 3, owner occupancy covenants. For homes, we usually point the land trust to your living estate plan or you personally as the beneficiary. For rentals and commercial, we point to an LLC, often a Wyoming or Nevada LLC, feeding state-specific subsidiaries. So facts dictate the map. In other words, an LLC in the state where the property is located as the beneficiary, and the owner of all your LLCs is typically a Wyoming LLC. Next step, equity stripping. Part 1, inside line. This is where the asset stops looking like a piñata. We record a commercially reasonable equity line of credit against each property, initially from an entity in your plan, such as your Cook Islands LLC inside of your trust, or a Wyoming LLC in some cases. Proper promissory note, deeds of trust or mortgages, interest rate that's with the going rate, maturity. Now this is not cosmetic, it's paper with teeth. Okay? Visible equity vanishes from the county recorders. So does that stop every lawsuit? No, but it changes the math. Contingency cases live or die on collectability. So if you look illiquid, even when you remain operational, many plaintiffs won't fund the fight. Now, timing here matters. Build in calm waters. Courts scrutinize insider liens recorded after the lightning strikes. So when a storm is on the radar, we prepare to bring in next equity stripping part number 2, third-party lenders. So a third-party lender, initially, this lien is payable to an LLC that is in your structure, one of your LLCs. So what we do in part number 2, to legitimize the lien, we can have your LLC sell that lien, sell that mortgage to a third-party lender. Now, third-party lenders are the credibility multiplier. So we can sell or we can refinance insider liens to a bona fide outside lender. So now a perfected, seasoned lien sits ahead of everybody else, backed by actual dollars advanced. So these optics now become actual solid substance that can be defendable in court. Now, seasoning helps. The history of payments, accrued interest, market rate terms, arm's length, documentation, that all that matters. Independent underwriting, clean files. The more it looks like mainstream credit, because it is, the less oxygen the plaintiff has. So cliffhanger payoff coming next. Where that money lands. What are the proceeds from those mortgages from the third-party lender land, and why it changes negotiations before they start. Okay, where the money lives and why that matters. Now, we never park the proceeds in your domestic operating account. That's like a freeze me sign. Instead, proceeds flow to the LLC inside of your Cook Islands Trust. In other words, an offshore LLC inside of your Cook Islands Trust. In peaceful times, you manage the domestic LLCs. The offshore trustee is passive, doesn't do anything. You're in total control. When litigation hits, our licensed bonded Cook Islands trustee, our law firm, temporarily takes the helm, lawfully ignoring U.S. court orders because U.S. courts don't have jurisdiction in the Cook Islands. Now, if you're not familiar with the Cook Islands Trust, we have a lot of videos on Cook Islands Trust. You can watch them and get comfortable. And I think you'll be very comfortable once you understand how they work. So in other words, the Cook Islands trustee lawfully ignores U.S. court orders just the same way that a U.S. judge would lawfully ignore a Cook Islands order. Jurisdiction matters. The result, the dirt stays here and the equity lives somewhere else inside of your Cook Islands trust structure beyond their reach. So instead of arguing about your building, an attacker faces a first possession creditor offshore and a very long tunnel with no cheese at the end. Okay, now here's the filing that kills contingency math. Here it is. For business interest and movable assets, it's the UCC1 financing statement. So when you own a business, let's say you own a construction company or you're a physician, what we do here, the LLC, the offshore LLC, becomes a secured creditor to your company. We record a UCC1 lien against your company and everything that your company owns or your membership interest if it's an LLC. And we protect this by filing the UCC1. The world now sees a secured creditor in front of them. Then if needed again, we have our third-party lenders waiting in the wings to purchase that lien and put the proceeds into your international trust beyond their reach. Plaintiffs hate second place. Even a win can mean they just inherit a payment plan behind a creditor who gets paid first. For real estate, the analog is a recorded mortgage already in first position. Either way, the menu for plaintiff changes from steak to croutons. Okay, here's a case study, the 9-door portfolio. Here's a composite example. Daniel, one of our clients, changing the name here, a developer with 9 rentals. So we have 4 rentals in this example. He had 9, plus another building, a small office building worth about $12 million on paper. 2 disputes pop up. A slip and fall surfaces. He's titled personally. Google makes him look like a buffet. So we retitle each address into its own land trust. Each trust names an LLC as a beneficiary. A Wyoming LLC owns all of those LLCs. So Daniel owns the Wyoming company that owns the other LLCs that are the beneficiaries of the trust. So we have each property in a land trust. And again, the LLC is a beneficiary of each land trust. And then a Wyoming LLC owns all of these LLCs because it has better charging order protection than most state LLCs. Then we record across the portfolio and later sell 2 liens to third-party lenders, moving $3.2 million offshore into the Cook Islands LLC. We file UCC1s against the operating company's equipment and receivables and then get a third-party lender to purchase the UCC1s and put the proceeds offshore as well. Outcome? Plaintiffs' counsel pivots from take the buildings to can we talk settlement. Get it? So both suits resolve for cents on the dollar. No fire sale. Cash flow continues. Credit intact. Okay, so why not title U.S. properties here directly to the Cook Islands Trust? Why don't we do that? Here's the answer. Because a U.S. judge doesn't need you to sell your building. They can appoint a receiver, collect rents, force compliance, and order a sale. Local land equals local power. So that's why we title to land trust for privacy, make domestic LLCs the beneficiaries for separation, strip the equity with liens that can be sold or assigned, and then let proceeds and secured positions trace back to the LLC inside of your Cook Islands Trust, totally beyond U.S. court reach. So dirt's here, equity's there. Simple and effective. So again, business interests, same spine, new limbs. Operating companies, practices, e-commerce brands, same logic. We extend secured lines of credit from your trust LLC to your business initially. Secure it with a blanket lien and file a UCC1. Okay, now your business has a lien against it. Your whatever company you own has a lien against it. Vendors and plaintiffs see a first position creditor already ahead of them. We also cross-collateralize. Your real estate entity borrows, your operating company guarantees. Both are encumbered, and if somebody sues the company, they're behind a creditor. If somebody sues you, they run into the charging order wall and the lien. Okay, now let's talk about taxes, banking, and practicalities. Taxes. Properly drafted, a land trust is disregarded for tax purposes. Depreciation and income pass right through. LLCs, the way we set them up, are also pass through. They just pass through to your personal tax returns. Your Cook Islands Trust is a grantor trust for U.S. tax purposes. You report your worldwide income. So in other words, it keeps the tax simple. Everything just flows through to you as if you didn't have these structures. So this is legal, transparent planning, no tax evasion, no nonsense. Coordinate it with your CPA. Everything's done legally, properly, and compliant tax-wise. Now, banking and insurance. Title offices see the structure every day. Lenders care that the liens and the real payments are clean. We maintain robust property, landlord, and umbrella coverage. We name the correct parties, trustees on the title, beneficiary, LLC as needed. Don't trade insurance for cleverness. Okay, lenders. For owner-occupied homes, keep covenants pristine. So we sequence the move to respect contracts while accomplishing asset protection so nobody can take everything away from you. Okay, now timing and ethics. First of all, do this before trouble. After you're sued, courts can examine transfers and insider liens. We can still do it after you're sued, but it looks a lot better to do it beforehand, as early in the game as possible. Don't wait to do this. Do this early, I'm telling you. We still have tools, especially third-party lenders, but the best leverage is built when the waters are calm. Ethically, we protect from predatory litigation. We don't dodge lawful debts. We don't get involved with any kind of criminal proceeds or anything of that nature. We only do this for ethical purposes. When there's a valid obligation, our goal is negotiated business-like outcomes with the odds in your favor. The Cook Islands Trust is a shield, not a toy. Okay, here's a case study. The dentist and the vanishing equity. Here's a composite story. Dr. L owned his office building free and clear. Prime targets. Before a patient dispute escalated, we retitled to a land trust, made his Wyoming LLC the beneficiary, recorded a first position working capital lien, and then sold that lien to a third-party lender. Proceeds went into the Cook Islands Trust LLCs. The plaintiff's tone changed from "see you in court" to "what would you take?" Real estate continued to produce rent. Collectible equity had moved. Quiet settlement, practice untouched. Okay, so here's the one sentence that wins negotiations. Plaintiffs' lawyers, after real diligence, say even if we win, we are behind the secured creditor. That's the goal. If you forget everything else, make sure the secured creditor is your Cook Islands Trust LLC initially, and that you notify us so that our secured lender can purchase the lien and put the proceeds into your offshore trust. So want to do this week? If your net worth is between $1 and $20 million, especially if you own multiple doors, timing matters. Privacy can be built in a day and lost in a moment. Liens need seasoning. Lenders need diligence. And lawsuits never text "on my way." Schedule a strategy call with us at assetprotectionplanners.com. We've built more Cook Islands Trust than any firm in the world. And visit our website. You can get a lot of free information there. But if you're serious and not curious, reach out. For almost 3 decades, we've designed the exact structure that we just walked through in our illustrations: land trust for privacy, LLC beneficiaries for separation, equity stripping that moves value offshore, and a licensed bonded trustee company that steps in only when needed. So in calm seas, you manage. In storms, we protect. So here's a final recap. 1 land trust for property, for privacy and containment. LLC is the beneficiary of each land trust, except for your personal residence. That provides liability separation and charging order leverage. Equity stripping, so these liens reduce visible equity and move value into claims and cash controlled by your trust LLC. Next, offshore destination. Proceeds of the loans sit with an LLC inside of your Cook Islands Trust, outside of easy reach of U.S. courts. And the killer is filing the UCC1 for your business assets recorded. We record a seasoned mortgage for real estate and a UCC1 against your business and other personal assets. So that's what scares the contingency math. So if this delivered value, subscribe now if you haven't. We do deep dives like this every week. And when you want a done-for-you plan, assetprotectionplanners.com. I'm the business guy, the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. So sleep well, no matter how loud the thunder gets.